One of the most hotly contested areas in workers' compensation today is over the certifications of maximum medical improvement and impairment ratings. Traditionally, all you had to do was file a DWC 32 requesting a designated doctor or request a hearing, and then you never had problems with any deadlines. However, things have changed. Matt, what's changed in reference to disputing certifications of maximum medical improvement?
Well, you're going to get your impairment rating from one of 4 different doctors. It might be your treating doctor or a referral from your treating doctor. It could be the state-appointed designated doctor or even the insurance company's doctor that we call an RME for a required medical examiner. When one of those doctors determines that you've reached maximum medical improvement, they're going to fill out form DWC 69, and we'll provide a link to it in the comments below so you can take a look at it, and you'll be able to recognize it and understand it when it comes in the mail, because you want to be prepared. So you'll get the DWC 69 in the mail, and once that happens, you're going to no longer be eligible for temporary income benefits to cover your lost wages. You're going to then begin to get impairment income benefits if you're owed anything. And so if you disagree with that, how do you dispute it? Well, there's 2 different ways. The first way is to request a designated doctor by filing form DWC 32. The problem with this method is that it only works some of the time, not all of the time. It only works if there's never been a designated doctor on your case before. If there has been a designated doctor on your case, then the only way you can file a dispute is to file form DWC 45 and request a benefit review conference. Requesting a benefit review conference starts the litigation process where you're going to end up in some hearings over your impairment rating. The problem with these 2 methods is that they're very difficult. The division has put some hurdles in your way, and you're going to have to overcome them. The first is with the request for designated doctor. It's a very long form, and it's a form that asks a lot of questions about things that you're not going to know the answers to. The other method, the 45, requesting the BRC, requires you to call the adjuster and try to negotiate your impairment rating before you ever request the division's attempts to resolve it through the benefit review conference. Those are both 2 pretty hard things to do. It's very complicated. And so if you do not do that correctly, the division says, well, then you never did it at all. And so they'll try to tell you that you never filed a dispute and that your impairment rating has become final. And it becomes final if you never file the dispute within 90 days. We call that the 90-day rule. Once you receive the DWC 69 in the mail, you have 90 days to file the dispute, or it's final and they'll try to tell you that you can't do anything about it. But if you're in that situation, talk to a lawyer, because there are some exceptions to the rule.
Okay. As Matt said, there are certain windows that you have to be very conscious of. And the certification of maximum medical improvement along with the impairment rating is one of the most important. You only have 90 days from the date that they can establish that you received the certification. With that, not only do you have to dispute that certification from the doctor, you have to get an alternative certification and have it ready when you talk with the insurance carrier to see if they'll agree with your doctor before you request the benefit review conference. So there's a lot of very finite things that you have to do in a very limited amount of time. So always make sure you're conscious of when you receive any certification of maximum medical improvement, because it could very strongly affect the type of benefits you receive.